My name is Monica Milton. I am the Counsel for Public Defense and Special Projects here at NACDL, and this week's Engage and Exchange is brought to you by our Corrections Committee related to earned time credits and pattern for defense attorneys. I do want to let you all know that typically Engage and Exchange is a member benefit. So if you do like this program and you'd like to see more of this, which we them throughout all of next year, please consider becoming a member. We will have a couple more that are not a member benefit that you should join, but we do encourage you to always become a member. This is particularly important for defense attorneys. And we have a ton of content that is unique to Engage and Exchange that others won't have access to. And so you should consider joining. I will pass this over to Pat Cresta-Savage, who is the co-chair of our Corrections Committee. But I do want to say that if you have questions throughout the program, so please put it in the chat. You do not need to unmute or open your cameras. Just put it in the chat and the questions will be taken at the end of the program because there's a lot to cover. So feel free as the program is happening to put your questions in the chat, but they will be addressed at the end of the program. This program will be recorded, and as long as you're registered, you will receive post-program materials, including slides, any links mentioned in the presentation, and any questions you have, you can direct them to me, mmilton@nacdl.org if you don't receive it for some reason. So I am going to pass it over to Pat, who will introduce you to our speakers today.
Thank you, Monica, Shuli, and everyone at NACDL for making this possible. Without you, this wouldn't happen. Welcome to the Corrections Committee webinar on First Step Act, a presentation regarding pattern scoring and good and earned time credits. My name is Pat Cresta-Savage. I am chair of the Corrections Committee. We have a wonderful group of committee members who have done amazing work in advocating for our clients. We try to meet on the third Thursday of every month if possible and welcome you to join us. However, that is a member benefit, so we also urge you to join NACDL. The benefits to joining are endless, including being part of projects and webinars such as this one today. We're proud to have you join us today, which is the second in a three-part series regarding all things BOP. As you remember, our first presentation back in November was on BOP basics, where we referenced the How to Navigate the Prison System Guide on the NACDL website. If you go to the NACDL site and search, you can connect to links that will take you to relevant forms and other information that will aid you in navigating prisons from pretrial, trial, sentencing, and post-conviction. Today's presentation on the First Step Act and good and earned time credits, along with post-conviction issues, including obtaining records and working through BOP administrative processes, is sponsored by the committee. Two of our committee members who are excellent, Elizabeth Blackwood and Alison Guernsey, will be presenting today. There's a lot to cover and we will entertain questions. We ask you to put your questions in the chat and I'll try to monitor them by presenting them to our speakers toward the end of the presentation. We want to know about the issues that you're facing and welcome your feedback and input regarding these issues. First, I'd like to introduce Elizabeth Blackwood. She is counsel and director for the First Step Act Resource Center at the National Association of Criminal Defense Lawyers. And while at NACDL, Beth has managed the Federal Compassionate Release Clearinghouse, which trains pro bono attorneys to file reduction in sentence motions for federal prisoners and has resulted in reduced sentences for over 250 individuals. Before joining NACDL, Beth practiced for 11 years as an assistant federal defender and research and writing attorney at the Federal Public Defenders of Western North Carolina, where she represented indigent defendants charged with a wide variety of federal crimes, including drug and firearm offenses, violent crimes, fraud, and sex offenses. Beth represented clients through every stage of a criminal case, including pre-indictment, pre-trial, plea negotiations, trial, and sentencing. She also handled numerous habeas proceedings and appeals before the Fourth Circuit Court of Appeals. She also served on the Clemency Project in 2014 to assist federal inmates petitioning to have sentences commuted by the President of the United States. She holds a BA from the University of North Carolina at Chapel Hill and a JD from the University of Michigan Law School, where she was executive editor of the Michigan Journal of Race and Law. Alison Guernsey is a clinical professor at the University of Iowa College of Law, where she directs the law school's federal criminal defense clinic. Under her supervision, law students represent indigent people charged with federal offenses in the U.S. district courts for the northern and southern districts of Iowa, as well as various federal courts of appeals. Professor Guernsey's clinic is one of the two trial-level federal criminal defense clinics in the nation. Following the passage of the First Step Act of 2018, Professor Guernsey started the clinic's decarceration project, which focuses on sentencing reduction litigation under 18 U.S.C. 3582 and 28 U.S.C. 2241, as well as executive clemency. The goal is to seek the release of people who are serving inordinately long terms of imprisonment, regardless of their crimes. Before joining Iowa law, Professor Guernsey was the supervising attorney with the Federal Defenders of Eastern Washington, a term law clerk for the Honorable Michael Malloy, U.S. Court of Appeals for the Eighth Circuit, and a term law clerk for the Honorable Karen Nelson Moore, U.S. Court of Appeals for the Sixth Circuit. We're proud to have them as committee members, and we look forward to the presentation. Elizabeth?
Hi, nice to meet you all. We are excited to do this presentation about earned time credits and pattern. I think Alison is going to do a brief poll before we start to just get an idea of what everyone's familiarity is with this subject.
Yeah, so as Beth and I go through this presentation, it would be helpful for us to know how familiar you are with earned time credits and patterns so that we're able to tailor the details of what we tell you to your experience. So it should be really quick. I promise that's the last poll. You don't need to do anything else except for listen. And Shuli, if you could share those results once you have them, that'd be great. Just help us gauge. Good, a good mix. All right, and thankfully not many of you are very familiar, so we won't bore you, and I will turn it over to Beth to start.
All right, so as we get going with this, I want to start out with the statute that made all of this possible, the First Step Act, and just a very brief background of what happened with this statute and how it has affected pattern and earned time credits. So almost exactly 5 years ago, the First Step Act was passed, and this was an expansive federal criminal law bill that had broad bipartisan support. It's actually kind of hard to imagine something like this passing today, but it did, and it was really exciting, really expansive, and it had two main parts. It was front-end sentencing reforms, and that was an effort to increase fairness in sentencing by reforming a lot of the very punitive mandatory minimum sentencing laws in federal criminal law. And then there were also some back-end reforms, and these are the corrections reforms. And these were efforts to improve prison conditions and also to encourage people who are incarcerated to take recidivism reduction programming to help with recidivism rates when they're released from prison. And so this is where earned time credits really come into play. And so this is sort of just a breakdown of some of the major parts of the First Step Act. And you can see that the risk and needs assessment, which is pattern, and earned time credits are right at the front. This was really the centerpiece in some ways of the First Step Act. It was a novel system, and it had a slow rollout. A lot of these sentencing reforms happened immediately, and we saw their impact. But the pattern and earned time credits they gave BOP a lot of time to get things ready. And so there was a slower rollout. And so that's why it's just really starting to make it into everyone's understanding of federal practice at this point, 5 years later after the First Step Act was passed. And just quickly, I want to make a distinction between good time credits and earned time credits. Sometimes people get them confused because they do sound very similar, but good time credits pre-existed the First Step Act, but the First Step Act did change it. It updated it so that individuals could get 15% of their sentence or 54 days off if they had sentences over a year. And this applied across the board unless someone lost their credits due to disciplinary violations. In contrast, the earned time credits was a brand new program created by the First Step Act, and it allows eligible individuals, not everyone, but eligible individuals to earn credits for successfully completing program that they could apply for early release from prison. And so now we're going to address pattern and needs assessment, because these are the things that you need to understand to know how earned time credits work. So in order to earn time credits at all, you have to have a risk assessment and a needs assessment. And the risk assessment gives us a pattern score, and the needs assessment helps us, is what the BOP uses to determine what programming an individual needs to take. So pattern is the risk assessment tool. It stands for Prisoner Assessment Tool Targeting Estimated Risk and Needs. So I'm sure that someone was very proud of that acronym, but effectively what this is it's a tool, an algorithm that uses specific factors to classify someone as being either a minimum, low, medium, or high risk of recidivism. And the Bureau of Prisons defines recidivism as rearrest or return to BOP custody. It's not defined as reconviction. Why does pattern matter? The pattern score is very important because it determines how many earned time credits you can collect if you're eligible, and if you can apply them for early release at all. So the pattern score is really important to earned time credits. But what's also interesting is that pattern has really creeped into other areas of federal law for which it wasn't really intended. We saw it most specifically with CARES Act home confinement, where one's pattern score was criterion that the BOP used to determine whether or not medically vulnerable individuals could be released from BOP custody and back to their homes. We also see it come up quite a bit in reduction in sentence or compassionate release motions on both sides for the defense and the government. So for better or for worse, and mainly for worse, we've really seen pattern creep into other areas of criminal law as well. So we are currently on our 4th version of pattern. It was released last April, pattern 1.3. When this version of pattern was released, it raised the cut points, which is the difference between the different categories, and raised it to allow there to be more minimum and low scores. We are hopeful there'll be another version of pattern at some point, but right now we are still working with pattern 1.3, and it's what you'll find on the BOP website as well. I'm going to show you the pattern score sheet in a minute, but just to point out that pattern has both general and violent scores. The higher score in either category is what controls. The reassessments for individuals' pattern scores, they occur at least once a year. Sometimes they're more often, and that's sometimes required based on where they are in their sentence. But we have seen individuals get reassessed as recently or as quickly as every 6 months, but they should happen at least once a year. So this is a pattern scoring sheet. There are different ones for male and females, and this is the male one. This is for pattern 1.3. And pattern, you can see it has these different factors here, and they use both static and dynamic factors. So the dynamic factors are ones that individuals can change. Their programming, your education, your work history. And the static factors, those are the dynamic factors. And the static factors are ones that can't change, like age and criminal history. And you might notice just looking at this, that age and criminal history have far more points than anything else. And those are going to be adding to your sentence. You can have points reduced through a number of the dynamic factors, but those are far fewer points that you're going to be getting off of your sentence. So just as an example, for your age, if you have an individual who's 25 years old, they're going to get 35 points under the general score just right off of the bat. And if they come in with a criminal history category of 4, they're going to get 24 points right off the bat. So that's a total of 59 points. And you may get some reductions here or there, but you're going to be really stuck around the 59-point area. And you can see how this plays in with the cut points, because if you have 55 points or more, you are a high. So that individual, that 25-year-old who's a category 4, is you're probably going to be going into Bureau of Prisons around, I mean, he might have a couple points reduced for programming or GED, but really they're going to be at a high or at a high level of a medium, or at the top score of the medium. So it's going to be very hard for them to get to a minimum or a low, which is important for earned time credits. That's really where you want to be to get the ultimate benefit of the earned time credit program. And this brings us to a lot of the criticism there's been of pattern over the years, these sticky categories where these characteristics for age and criminal history are given by far the greatest weight. And it does not allow for personal growth to make significant differences in individuals' pattern scores. There's also been a lot of criticism about the racial disparities in pattern. Over 70% of Black prisoners are medium or high, according to a study from 2021. And the Department of Justice itself has acknowledged that pattern overpredicts recidivism in Black, Hispanic, and Asian people compared to white people. And advocates have argued that this has a lot to do with the definition of recidivism for pattern, which is tied to the rate of rearrest, and the fact that we have these specific categories for age and criminal history and for education that tend to disadvantage and just have baked-in disparities that tend to overemphasize the risk of recidivism for people of color. There's been a lot of effort to try to get pattern change, advocacy that's been done. I know that's something in the most recent First Step Act report that the National Institute of Justice, which is the division of the DOJ that monitors pattern, that they're considering, particularly the definition of recidivism. But that is a big concern with it. I'm sort of touching on these issues. There's been a lot of scholarship about this. If you ever want to do a deep dive about it, a good starting place is this Brennan Center report on First Step Act reforms, which links to a lot of the great scholarship on this. But I just wanted to touch on this, that there's really been a lot of criticism. Pattern's only as good as the data it uses. And when the data overpredicts recidivism rates, then you're going to have a tool that does that as well. Also, we've had a lot of issues with the technical errors in pattern. One of the earlier versions put 14,000 individuals in the wrong pattern category. So there's a lot of criticism with pattern as well, which is noteworthy for a program that has so much weight to whether or not someone gets out of prison. So I'm moving on to the needs assessment. Pattern gives you your risk assessment. You're a minimum, low, medium, or high. And now you need your needs assessment. This is primarily done through a survey. It's called the Spark 13 survey that an individual takes when they first get into prison. This and the PSR is what the BOP is going to use to determine your programming. And the programming is assigned from 13 different areas. These are the ones here that are listed. A lot of it is taken through this Spark 13 survey that the incarcerated person will be filling out. But a lot of this is also taken from the PSR. So that's just something to keep in mind when you and your client are filling out PSR paperwork during your interviews, to make sure you really flesh out some of these categories, because it will be used for their needs assessment. A really important thing for all attorneys to know and to advise their clients is that they have to do the needs assessment in order to get earned time credits and to participate in the program. If you refuse to participate in any of the needs assessment and you don't fill out the Spark 13 survey, then you will not be able to participate in the earned time credit program. There was a lot of confusion about this at the very beginning of the earned time credit program really getting started. A lot of people didn't know they needed to fill this out. The BOP did give them a grace period, but at this point, people really need to know that you have to participate in this needs assessment at the beginning of your time in Bureau of Prisons. This is what the needs assessment is going to look like in an individual's paperwork, in case you want to take a look at it for your client. And then once you're in the needs, once you get your needs assessment, you'll be assigned programming. So the programming is going to be evidence-based recidivism reduction programs or productive activities. The EBRRs are more structured programmings. It's things like RDAP, cognitive behavioral therapy, financial literacy, programs that are likely to reduce recidivism according to the BOP. Productive activities are a little bit looser. It's things like NA and AA and some hobbies that people might be interested in. Often volunteers from inside of the facilities can teach these programs as well. But the place you're really going to look at for these programs is this guide. This is found on the BOP website. It's the approved programs guide. Your program must be in this to count for earned time credits. Right now, it's a 75-page guide. It keeps getting bigger, which is good because they're adding more programs. It's updated often. It's categorized. It shows you which prisons have these programs. So it might be worth taking a look at with your client in case you want to make some sort of recommendation for designation. But this is something to look at and figure out where the programs are going to be. So now we move to the earned time credit program proper. So earned time credits, what are they? How do you get them? Who, what, when, where, why, and how? And I just wanted to take the note to say that one really interesting historical fact about the earned time credit program is that initially there was a great deal of concern that this was not going to be a really fulsome program and this was not going to have a huge impact on federally incarcerated people. And that's because one of the earlier rules were released really seemed to claw back a lot of the provisions that were in the First Step Act. There was a lot of advocacy by stakeholders. And then in January of 2022, the BOP released the final earned time credit rule, and it was actually much better than people had expected. It was a rule with a lot more opportunity for individuals. And this is in large part why I think this has gotten a lot more attention, is that people are seeing some real impact in their sentences if they comply with all the conditions of the program. So I'm calling this earned time credits or ETCs, but you often see it written in different ways. BOP often calls it First Step Act time credits, but they're all the same thing. They're all part of this same program, the earned time credit program. So what are earned time credits? They are effectively credits that you can collect and apply to early release from prison if you're eligible and you've successfully completed the programming that's been assigned to you by the Bureau of Prisons. The best places to really get to the heart of this program, if you really want to look into it, is the First Step Act, the statute, the BOP's rule, and also the BOP program statement. At the very end of this PowerPoint, I have a list of all of our resources that I cite to throughout this PowerPoint, and there are hyperlinks there. But the statute, rule, and policy, this is where you're going to find really the structure of the earned time credit rules are found in these provisions. So if you're eligible, what are you earning with earned time credits? If you are a minimum or low pattern score in your last 2 assessments, you can earn up to a year off of supervised release. So this is release from Bureau of Prisons, like you were on supervised release. You have to have a term of supervised release in your judgment for this to apply. And again, the maximum you can get for this is 1 year. If you have more than a year of credits, you could potentially use that for pre-release custody. And this is released to a halfway house or to home confinement. You likely need to be minimum or low your last 2 assessments, or the warden can approve you for release. In this situation, you are still in Bureau of Prisons custody. But as I said, it can be more than a year that you get off for this pre-release custody. I clicked the wrong way. Go this way. So what about if you're ineligible? And I'm going to talk more in detail about what makes you eligible or ineligible. But for this purpose, what happens to the folks who are ineligible? Well, they don't earn time credits, but they can participate in the programming still and get other privileges, phone privileges, transfer to a different facility, certain commissary and email privileges. The caveat to this is that I've heard from individuals in Bureau of Prisons anecdotally that due to the limited programming in BOP, realistically, the programming is only going to be made available to people who are eligible. So a lot of ineligible people aren't able to take the programming and therefore can't get access to these privileges. I'm sure that's different in different facilities, but just a note that just because this is available doesn't mean that the individuals will have access to this programming. So how much do you earn for earned time credits? One thing to note is that if you're eligible, regardless of your pattern score, you can earn time credits, but the amount changes based on your pattern score. So if you are a medium or a high, you're earning 10 days of credit for every 30 days of programming that you take. If you're a minimum or a low, you get 15 days for every 30 days you take. The credits get updated every 30-day period, and you don't have to successfully complete the program to earn credits. This was a change recently in the BOP policy. As long as you're in the program and you're participating and you're not opting out, you will get credit for the programming that you're participating in. So when can you start earning these time credits? This is sort of an interesting issue. The First Step Act states that the date the prisoner's sentence commences is when you can start earning time credit. And the First Step Act specifically states that pretrial confinement, any prior incarceration sentence does not count. It's once the sentence is commenced, once you're sentenced. The BOP rule and the BOP policy statement, they define when your sentence commences as the date that you arrive at the facility or when you voluntarily surrender in the BOP facility. So there's at least one court that's held that this is an additional exclusion beyond what the First Step Act says. And in this case, they have required the BOP to credit the amount of time the individual had between their sentencing and when they arrived in BOP. So it seems like the situation is right now that the BOP is still considering your sentence commence date and the date the earned time credit starts as the date you arrive in prison, but there is, I think, a pretty good and strong argument that it should be the date that you are sentenced. So that's something that, Alison will teach you how to challenge in litigation, and something hopefully advocates can change as well with the BOP policy in the future. So who's earning these credits? You've got to be in BOP custody. This also includes being in the halfway house or home confinement. These individuals should be able to earn time credits, although that has been difficult, but they are supposed to be earning time credits. And you should be successfully participating in your programming and eligible. So we're going to unpack the terms successfully participating and eligible. So simply, successfully participating means you're in the programming recommended by BOP and you're complying with the requirements. If you cannot get into the program because you're on the wait list, you're still earning even if you're on the wait list for at least 2 assessment periods, maybe even more. So this really shows the BOP's effort to try to give people the benefit of the credits as long as they're opting in. So it's not that individual's fault that the BOP doesn't have enough slots, so they're not going to be penalizing that individual because they're on the wait list. You still can earn credits. You're not successfully participating if you're in the SHU for some sort of disciplinary violation. But please note that if you're in administrative detention for some sort of safety reason or health reason, then you're okay. Then you're still successfully participating. It has to be the SHU and it has to be for disciplinary reasons. If you're not in the BOP because of a writ, because you've been taken to the hospital, then you're not earning time credits. Or if you're in a psych hold. The biggest category that people run into is opting out. If you refuse to participate in the programming, if you don't complete the needs assessment survey, then you're opting out and you're not earning credits. You can always opt back in. That is a possibility, but at least for that time period when you're designated as opting out, you're not earning credits. And I should note that it has to be documented by the staff if they're claiming that you've opted out. So ineligibility. This is a big issue because around 43% of federal prisoners are ineligible for earning time credits. This means that they will just not ever be able to earn time credits. You're ineligible if you have a disqualifying current conviction, prior conviction, or DC code offenders. And I put right now there because there is a possibility that DC code offenders down the road could be able to earn time credits, but right now, these individuals cannot earn time credits, unfortunately. If you're ineligible, again, you can still earn other privileges, perhaps the increased commissary, being transferred to a facility closer to your home. However, as I mentioned, there are availability issues for that. So the biggest category of disqualification is current convictions. There's over 60 categories that are enumerated in the First Step Act by statute. There's no getting around them. If you're convicted of one of these offenses, then you cannot earn time credits. That's just not going to be part of your BOP time, or your experience there. So when you look at the statute, which excludes or lists these disqualifying convictions, be sure to check out the specific subsection. And also note that some of these offenses require court findings. So that's often why you'll see the BOP is going to be looking at the PSR and the statement of reasons, as well as the judgment and conviction to determine if someone is disqualified. So really one of the best things to have on hand is this excellent one-pager from the federal defenders. This very succinctly lists all the ineligible offenses for earned time credits. And it's not necessarily what you might expect. There's a lot of negotiations that were done for the First Step Act, and you really see some of this play out. And you shouldn't assume that your client's going to be qualified or disqualified for earned time credits until you really thoroughly look through this list. I'm taking a lot of these slides from this excellent presentation that the defenders did, but I'm just going to go through some of the more common federal criminal convictions that we see and talk about which ones qualify and which ones don't. So 924C is always a disqualifying offense. Even if your client also has another offense of a conviction that is qualifying, my understanding is that the 924C knocks you out of contention completely for earning time credits. In contrast, felon in possession of a firearm and even armed career criminal, if you're convicted of that or if that enhancement applies, you still can earn time credits. For robberies, if it's bank robbery resulting in death, you're disqualified for earned time credits. However, if it's armed or unarmed bank robbery, you are still able to earn time credits. Carjacking disqualifies you, but Hobbs Act robbery, you are still qualified for earned time credits. Sex offenses, this probably isn't a huge surprise, but many of the sex offenses are disqualifying. Chapter 109A for sexual abuse, and any child pornography offenses, including possession, will disqualify you, as will failure to register as a sex offender. However, transportation for prostitution, coercion and enticement, transportation of minors, these are still qualifying offenses. If you're convicted of these things, you can still earn time credits. So something to keep in mind for plea agreements and plea negotiations. If all things are being equal, you might want to consider offenses that allow your client to earn time credits. Assaults, this is where you really need to look at the subsection. There are certain assaults that are disqualifying and others still allow you to earn time credits. So take a look at this very carefully as well when you are negotiating pleas for your clients. Couple of other notable exclusions. I really want to talk about the first two. So any drug trafficking offense that results in death or serious bodily injury. This is the only drug trafficking offense under B1C that will exclude you from earned time credits. Everything else seems to involve 841 B1A and B1B. And then the second one, if you have a B1A or B1B conviction and involves a fentanyl or a fentanyl analog, then you are disqualified. And I mentioned before that there are a few convictions with court-found ineligibilities that will exclude you from earned time credits. So any B1A, B1B drug trafficking offense, if it's heroin or meth and the court finds a role enhancement. And then any B1A or B1B offense, if it's any drug and the court finds that the offense conduct involved fentanyl or an analog and there's a role enhancement. So these are tricky. Be very aware of what's in your PSR to make sure your client is not excluded from earned time credits. So disqualifying prior convictions. This doesn't come up quite so much because there are so many offenses that disqualify, the current convictions that disqualify people. If you have a client who's convicted of an instant offense and it appears at first glance to be a violent felony, you might want to take a closer look at this, this provision, because if you are convicted of an offense that's not already excluded and it's a serious violent felony under the 3-strike statute, 3559C, and your client has a prior conviction that falls under an enumerated list and they've been sentenced to that offense for more than 1 year, then your client might be disqualified. Again, this would just be for people who aren't already disqualified based on their instant offense, but they have a violent felony that they're convicted of and they might have something in their record. So it's a little tricky. There's categorical analysis that might be involved. The BOP itself notes that this is going to be tricky, and they advise you to speak to their Consolidated Legal Center for guidance. You can make a strategic decision about whether or not you might want to do that in your case, and to see if the BOP believes that your client will not be qualified or will be disqualified for earned time credits. Another area that's gotten a lot of attention is deportable persons and detainers, because this has changed a lot in the past couple of years. So what hasn't changed is that, under the First Step Act, if you are convicted of illegal reentry or aiding illegal reentry, you are disqualified from earning time credits. You can neither earn nor apply earned time credits. If you're convicted of a different offense and you're subject to a final order of removal, then you can earn, but you can't apply those credits. So if it was a low-level drug trafficking offense and there's a final order of removal, you can earn your time credits, but you can't apply them for early release. So I guess the theory behind that is if somehow the final order of removal was resolved or taken away, then you would be able to get those credits at that time. But final order removal means there's no application of the credits. The area that has changed is in 2023, the BOP determined that if an individual has an unresolved immigration detainer or an unresolved pending criminal charges or detainers, so usually that would be an unresolved state detainer, then they can both earn and apply credits. So this was great news because previously those individuals could not apply their credits. The bad news is that the individual still has this detainer outstanding. So we know the BOP has attempted to deter individuals with these unresolved detainers from applying their credits because of a risk of rearrest. The BOP says they'll lose jurisdiction if that happens. It will become a technical escape. And there's also been reports that the BOP is not prioritizing bed space for these individuals with unresolved detainers, and instead it's being prioritized to individuals who don't have any sort of detainers on their file. So this is something that we're trying to resolve. This is of great concern. It seems sort of like the BOP giveth and the BOP taketh away for these individuals. So just something to flag for your clients if they do have unresolved detainers, that they can get released if they're eligible. They can earn time credits, they can apply them, but they may be subject to some of the issues with those detainers, and they may have trouble getting a bed space in a halfway house as well. Okay, so you're eligible, you've been doing everything you're supposed to, you're earning your time credits. When do you get to apply them? When do you get to cash them in? This occurs when the number of credits you've earned equals the time left on your sentence. And also if you're a minimum or low on your last 2 risk assessments, or if the warden approves. So realistically, this is what this would look like. If you're someone who has 120 months of time that you're actually serving, and you're subtracting from this good time credit, pre-release custody, if applicable, RDAP, and they're serving 120 months, then if they're a minimum or low, after 80 months, they will have 40 months of earned time credits to use. So a year of that can be on supervised release. The rest of it would be in a halfway house or home confinement, so pre-release custody. So if you're a medium or high after 90 months, then you'll have 30 months of earned time credits that you can use because you'll have 30 months left on your sentence. So I have to do the math every time I do this presentation, but this is right. So it's kind of interesting because the higher your sentence is, the more credits you will ultimately be able to earn. So a lot that you can gain by participating in this program if you're eligible. So what about eligible medium or high clients, or medium or high pattern level clients? So the First Step Act says that they should have a path forward to getting released. And the BOP rule and the policy has created a lot of hoops that medium or high pattern folks can jump through. And ultimately the warden has to release them. So it is possible for individuals with medium or high pattern scores to get released onto pre-release custody. It's not supervised release for them, but they, in theory, could be released on pre-release custody. But we have not heard about it happening very often, if at all. I've never heard of anyone getting out who's a medium or high. So that just really points to the importance of having a minimum or low pattern score and all the issues that go along with pattern with that. Earned time credits, you can lose them. Violation of the rules, usually that's going to be a disciplinary violation that you can lose those earned time credits. However, unlike good time credit, you can actually earn your earned time credits back after clear conduct for 2 risk assessment periods. Warden also has the authority to restore time credits, and the loss of them can be appealed. If you're really getting, doing a deep dive into your client's earned time credit issues, there's 2 places that are important to look at. One is this First Step Act time credit assessment. This is automatically uploaded. The client should have a copy of this. It's a lot more involved than this. This is just sort of the top of it so you know what to look for. But every 30 days should be updating your client's earned time credits and gives you a lot of information about how that program is going for them. Also, if your client's a minimum or low, BOP is supposed to estimate a conditional projected release date for that individual if they continue earning time credits at a normal rate and there's no pause in that rate. And that's something you can find on the sentence monitoring computation data form. So the too long didn't read who actually is getting to use these earned time credits. It's individuals who aren't disqualified, and those with a minimum and low pattern score are the ones who really we're seeing cashing in and applying those earned time credits. And this is what this looks like over the past year from the 2023 First Step Act report. It shows that about 29% of federal prisoners are eligible minimum or low pattern scores. And so these are the people that are actually getting to fully use the earned time credit program. And I should note that this is a pretty big increase from 2022, where we saw about 21% of individuals being an eligible and minimum low pattern score. So I'm not sure if that speaks to the BOP doing a better job of not accidentally disqualifying people, but we are seeing more people being able to take advantage of the program this year at least, or this past year. And so with that, I'm going to pass it on to Alison, who's going to speak to the practical application for all of these earned time credit programs.
Beth, before we do that, there were 2 questions, I think, relative to your presentation.
Okay.
And one is, if an individual was, this is on extradition, if an individual was paroled into the country per an extradition, is this person eligible because they are technically not removable? Has this been litigated yet?
Alison, what do you think? I have not heard of that.
So I don't have the case off the top of my head, but I do recall there was a case out of Texas that was talking about individuals serving foreign convictions in the United States. And I will definitely look that up, and I can provide that information if you want to just email Monica or Shuli or Pat your response, and I can get that case to you. But generally they found not eligible, at least in this one case that I found.
And there was one question on the history of violence category on the pattern score sheet. Is that intended to capture only violence while in BOP custody, or is it also street violence? It seems like the latter wouldn't be fair because it would lead to double counting of a violent offense.
I believe the history of violence, this is where Jack Donson would be helpful, but I would have to look back at the First Step Act report, but I do believe that it is something that's categorized from their criminal history and from the Century reports and different BOP classifications that they use, because there is this different category for amount of period of time for not having any sort of violations in prison. So that's its own separate factor. So I do believe the history of violence takes into consideration past violence, and it's double counting. I mean, sure. And there's also criminal history. I mean, yeah, it's another concern about the pattern scores, that there's a lot of ways to increase your pattern score, but not a lot of ways to decrease it.
Yes, and Jack actually said, yes, there is a history. He just texted. Here's a segue for you, Alison, because you work in decarceration. What is the percentage for white Latino prisoners? And is it helpful to understand that in order to understand why there are 70% of Black persons incarcerated? And with that, we'll turn to you. If you know that,
I don't, I think that may have been referring to a piece of data that Beth gave. if I'm not mistaken. So I don't think I understand the context of the question well enough.
Right.
But I will look back at that question, and if it's something that I can't answer, I will.
All right. Take it away, Allison. Thank you.
Yeah. Okay, so Beth talked a lot about the background of pattern and earned time credits, who is eligible, how you earn, what you can do with those credits. And I think sometimes it's really easy to let your eyes sort of glaze over. It seems kind of complicated. Figuring out credits in the Bureau of Prisons is not something that longtime defenders have really had to do as part of the core of their work. But I really want to say and caution people to become as knowledgeable in earned time credits as they can for their client's sake. I think it's not only something that's just good for our clients, but it's also compelled by the rules of professional conduct when they talk about competency. And that's in large part because we're not talking about a collateral consequence. We are actually talking about part of the direct consequence associated with someone's conviction when they're convicted in federal court now. So when you're engaged in evaluations of whether or not something's a good plea deal or what kind of sentence your client is going to be serving, you need to know about earned time credits. Now, I say that with the understanding that this is pretty complex, and I think that what makes it even more complex is that we don't really know a lot about, we don't really know a lot about what the Bureau of Prisons is doing, and it seems to be incredibly decentralized. So that it's not really easy to judge what's going to happen in any particular prison. And for some reason, the slides keep advancing without me doing anything. So I'm going to try to go back here. But I wanted to just start with the statutory language because I think it's really important to emphasize that this is a mandatory program. The statute provides that people who are successfully participating in the EBRRs and the PAs shall earn the time credits as delineated in the statute. But not only that, but that those credits shall be applied towards time in pre-release custody or supervised release. So unlike a lot of the Bureau of Prisons programming that we can't really challenge because it involves a lot of discretion on behalf of the Bureau of Prisons, this is a mandatory program. So if our clients are eligible and they're earning, we have some traction when it comes to litigation. So how you can help your client obviously really depends on the chapter of the case and what stage you're involved in. And that would go from plea to sentencing, when they're actually in custody, and then frankly, when they're on supervised release. And I'm not going to talk in great detail about all of the things that you should be on the lookout for in each of those chapters, but I want to touch on the highlights, the things that you should start thinking about as you incorporate this into your defense advocacy practice. So turning first to plea agreements, this is really where I think defense lawyers can make the biggest difference for their clients. As Beth mentioned, there are a lot of crimes that are where you're rendered statutorily ineligible, and I think the list is 68 or something along those lines. So one of the things that you really, really need to do is you need to look at the statute that your client is charged under, and you need to make a determination as to whether or not they are ineligible to earn earned time credits. The statute delineates them. The federal defenders has that cheat sheet. The Bureau of Prisons even keeps a list. But you really want to make sure that you're relatively familiar with perhaps the most involved or the most frequent least seen convictions. It's really also important to remember that you're looking at each count of conviction, because each count of conviction could be an ineligible offense or it could be an eligible offense. Now, one of the things that to be on the lookout for and that Beth mentioned is that it's not just the statutory provision that renders someone eligible or ineligible, but in some contexts, it's going to be these judge-determined findings. So not only do you want to look for a charge bargain that gets out of the realm of an ineligible offense, but you also want to pay attention to those facts that could trigger ineligibility if found by a court. There are really sort of two main ones that I think we will all see in practice, and that would be the leader or role enhancement when you have a drug offense, or as Beth mentioned, the death or serious bodily injury resulting when you have a drug offense. So you need to look at every count. You need to think, what do these facts actually say about what happened? And then before you enter into a plea agreement, you want to make sure that you're trying to negotiate a way potential enhancements, or potential facts. Now, of course, we know that we are not always going to be able to succeed in charge bargaining or fact bargaining. So if you are pretty sure that your client is going to be ineligible because of the statute of conviction or because of a role enhancement or some other factual finding, then you can use that knowledge to try to bargain for a lesser sentence. And again, I know that that's an ideal world, in which case the prosecutors are on board with giving us lesser time. And some jurisdictions, I think that's going to be much easier than others. I do want to flag here too that when I talk about ineligibility, in some circumstances, I'm also talking about those people who have pattern scores that are either high or medium, because while you're technically eligible to earn, as Beth mentioned, those categories are really sticky, and I'll talk a little bit about this later, but it's really hard to bring them down. So while you may be earning, you may not actually ever be able to cash them in. So again, when we're looking at plea agreements, we need to make this a part of our negotiations, just like we do when we have non-citizen clients, when we're thinking about whether we're going to render them removable or not. This is a really important aspect of your plea negotiations because it is part of the direct consequence. It's not a collateral consequence, it's a direct consequence of the sentence that's imposed. So obviously, from plea agreements, we would move into the PSR. And the PSR is going to mirror what you can do to help your client in drafting the PSR, and having a favorable PSR is going to mirror sort of your plea negotiations. The first thing that you want to do is you always want to object to the role enhancements, because that goes directly to eligibility. And even if you don't win, you want to have that objection on the record. Who knows? Maybe someday you will actually prevail on that objection depending on your court. And so don't just let it lie. The second thing with respect to PSRs is objecting to fentanyl. And that's because fentanyl is a really sneaky drug when it comes to earned time credits. You don't actually have to have a conviction for fentanyl to be rendered ineligible for earned time credits if your offense involved fentanyl. So one of the things that's always a red flag for me, and I see it all the time now in my drug cases, is there's a pill that tests positive or presumptive positive for fentanyl. To the best of my ability, I will try to keep that out of the PSR. And I certainly will try to keep it out of the PSR if my client is also receiving a role enhancement, because a drug offense involving fentanyl and a role enhancement will render the person automatically ineligible for earned time credit. So the other things that I want to talk about, the 3 and 4, go to the pattern assessment that Beth was talking about, and in fact, that question about the history of violence. So as I mentioned, if you're a medium or a high, you're going to earn these credits provided that you're statutorily eligible, but that doesn't necessarily mean that you're going to be able to cash them in. And when we do that pattern assessment, when the BOP does that pattern assessment, they're going to look at the history of violence and they're going to look at the history of escapes. So to the extent that you can go through the PSR and cull or try to eliminate things that would demonstrate a history of violence or show a history of escape, that would be incredibly helpful. Now, I know that that's not always possible, but I also know, having done this, that I sometimes will not pay as much attention to the past convictions or object to the factual bases underlying those past convictions if I don't think they're going to make a difference to the guideline range or in the court's 3553A analysis. But that really has shifted now that the pattern score uses these two things, because they become such drivers and it's really hard to get out of those high categories once you're in them, that to the extent that we can help minimize our clients' likelihood of appearing in those higher categories, I think that we should. The other thing is the pattern score takes into account whether it's a serious history of violence or whether it was relatively minor, and the same thing with escape. So if I read a PSR and it talks about a history of escape, for example, but it was an escape that was just somebody not showing up to court, or maybe it was a walk away from a work release placement as opposed to an active escape, I will want the PSR to be amended to include those relatively minor facts, because I think at the end of the day, that's more helpful or positions our clients in a better place to be able to argue that they shouldn't get those points on their pattern score. Now, the fifth thing thing that you can do to help your client before your client ends up in prison is to actively contribute to Part C of the PSR. I know a lot of lawyers do this already, but you provide records to the probation office that outline your client's prior treatment, that outline your client's prior education, that outline your client's work experience. This can be really helpful to have documented in the PSR. So when they're doing not the pattern assessment, but the needs assessment, it becomes clearer what your client could or could not benefit from, making, I think at the end of the day, the recommendations that they receive more relevant to what they actually do need, as opposed to just a blanket, well, you need to do this program and this program and this program, because we don't have enough information. So I would really encourage you to actively contribute to the Part C of the PSR so that your PSR, the history and characteristics portion, is much more fleshed out. Now, I will give a word of caution with respect to that. I know this varies district to district, but in the districts where I practice, I do not have my client sign releases of information that allow the probation department to obtain those records. I obtain those records and then I provide them to the probation department, because I have seen in the past where those records do not contain favorable information to my client. And so it's ended up in the PSR because of me, frankly, right? I should have been the one vetting that. So again, I think one of the practices as we start to really develop the Part C is to take control of that process and to make sure that we're the ones requesting and getting the records, and not just signing blanket release forms to the probation department to do it. All right. So sentencing, or so detainers, this is another thing that often appears in the PSR, and Beth mentioned these a little bit earlier, so I won't go into too much detail, but I do want to say you want to make sure that you're identifying all detainers, and then you want to work to remove the criminal detainers before someone gets sent to the Bureau of Prisons. So generally, if my clients have outstanding criminal detainers, I will send letters to the jurisdictions where they have those outstanding warrants or those pending cases. And the rules of professional conduct allow us to do this as long as it's connected to the cases that we're currently working on in the jurisdictions where we are barred to practice. And so that way I can try to convince the court to go ahead and quash that warrant and maybe set a court hearing for 5, 6, 7 years in the future. If it's a relatively minor case, we've had quite a bit of success of just having the court contact the prosecutor, and then the case just gets dismissed. Now, I know this is not going to work for those big, really serious crimes of conviction, but even those minor detainers can be quite problematic. So take a look at them and try to get them resolved before your client goes away. And then I think you also really have to counsel your clients regarding ICE detainers. The shifting positions of the Bureau of Prisons, I think, put these clients particularly at risk. And so you want to be very candid with them about how the Bureau of Prisons has interpreted the rule. And as long as it's not a 1326, 1327 conviction, they're eligible to earn. But that it's going to be that they're very discouraged from applying those credits because the Bureau of Prisons is afraid that they will escape off into the ether. And in fact, they are not going to be prioritized for pre-release custody or placement in the RRC because bed space is already so short.
Alison, I apologize. There's a question to that issue. If I may ask it before we run out of time. What happens if you've earned time credits while having an unresolved detainer, which later turns into a final deportation order? Are the first earned time credits withdrawn?
Yeah, so that's actually a really complicated question, and I want to push it off to a little bit later because I think it bears upon another issue that I'm going to talk about, which is mixed convictions where you're serving 2 separate sentences. But it's a great question, and the answer is, I think the answer is the BOP would say you're screwed. I think that there are some ways that we could potentially argue against that, but I will address it a little bit later. Okay. All right, so where we are here. So what's the things, you've got your PSR and now you arrive at sentencing, and maybe you haven't been able to do everything that you hoped. And so your client is, facing an ineligible conviction. And so one of the things that you may want to do is argue the purpose of the First Step Act and earn time credits to the court when you're requesting a lesser sentence. So the congressional intent behind the earned time credits was really to incentivize rehabilitation and decarceration. Right? That's what makes it such a spectacular statute, is that we have decided now or at least we did 5 years ago, that we want to invest in people becoming better members of our community, both inside and out of prisons. But the problem, or the reality, is not a lot of people are actually being able to cash in on their rehabilitation efforts. And so one of the things that you can share with the court is, okay, first, my client's not statutorily eligible. I'm going to argue for a lesser sentence with community treatment because this person is going to be able to do the programming. They're just not going to be able to earn the credits or cash them in. The second thing to think about is if you know your client is going to go into prison with a high or a medium pattern score, the benefits associated, even if they're not statutorily eligible, are really illusory. So you can see that this graph came from the April 2023 report from the DOJ, and it shows that you have a lot of people in prison who are eligible, but they're in the high and the medium pattern categories, which means for all intents and purposes, they are not going to be able to cash in the chips that they've earned. And then you have on the right side of that graph, all of the people that are in fact ineligible. So really, if you look at the various ways that we can cut up people with respect to patterns and earn time credits, the most category, right, the greatest category of people are in fact not going to be able to really realize the benefits of the earned time credit scheme. And so we need to educate courts on that point. The other thing that I want to flag here is that I've heard from advocates across the country that when the U.S. Attorney's Office has gone into sentencing, arguing for a particular sentence, on occasion they've said, and because of the earned time credits, this person is now going to serve just a sort of a fraction of the sentence that they were going to receive because they're going to be released on pre-release custody. They're going to get a year off their sentence for the SR credit. That is really sort of chicken little, sky is falling, because pre-release custody we're seeing is really a unicorn. The number of people who are being released on this pre-release custody is not great. And in fact, the Bureau of Prisons acknowledges as much by just complaining about the fact that they don't have bed space or that they don't have the community support necessary to supervise people on home confinement. So there really is a way that you can use your client's ineligibility or your client's high or medium pattern score to argue for a downward variance, or at the very least, educate the court when the government comes in screaming about how the court must impose the sentence because otherwise the person will be released years early. I did forget to mention this too, but Beth had talked about it. Pattern is not only unfair in that you have a lot of people who can't cash in their chips, but pattern is also discriminatory. And this is from a recent report by the National Institute of Justice, which says that the pattern is generally predictive, generally accurate, but there is evidence that it overpredicts the risk of recidivism for several racial groups, and that this is the biggest problem related to pattern. So I think we should be using this in our sentencing advocacy. Okay. So I find it really complex and important but complex to keep in my mind how to parse my client's eligibility and to remember all of the things that I need to be thinking about when I'm engaged in plea negotiations. And so I read this book a while back called The Checklist Manifesto. And so what I have essentially done for all of the complicated decisions in my life is I create forms and I create checklists that help guide me through the various analyses that I need to do. It's also particularly helpful when you're teaching law students because it makes sure that they are able to understand the process by which you're working through. So this is an example of sort of a checklist that I use when I'm evaluating whether or not my client is going to be eligible for earned time credits. The column all the way to the left, I make my students or I list out the statute of conviction. And again, you're doing each statute because it will have a different eligibility determination. Then I will ask, I will go, are they categorically ineligible for each count of conviction? And then because those judge-made findings can be so sticky and so difficult, I've explicitly enumerated at least 4 of them and figured out which combinations will make my client ineligible for earned time credits. So if it's a heroin offense and there's a role enhancement, they're ineligible. If it's a meth offense and a role enhancement, they're ineligible. If it's drugs that involved fentanyl and there's a role enhancement, they're ineligible. Now, the one that I would add to this that wasn't sort of on my radar when I first created this was the death resulting column. So that would just go to the right of the role enhancement. The other thing that I want to flag for myself are the pattern factors that I can try to control with respect to PSR. And that's the history of violence, that's the history of escape. And so I just go through the PSR and I mark where I think that those things are going to appear. And then with respect to my non-citizen clients, I always want to ask whether there's an ICE detainer and then whether there's a final order of removal, because the ICE detainer and the final order of removal will affect cashing in, frankly. And then at the bottom of the sheet, I have sort of a guide that are questions that I ask myself when I'm engaged in plea negotiations or when I'm thinking about how I want to frame this case. And so I'll just go through this analysis and have a good sense of where my client may be when I'm engaged in negotiations with the prosecutor, but also then when I'm engaged in client counseling. Okay. The other thing that I think is important for us to start doing, and I didn't really do this until the last year, and so I want to flag it here, and that's keep track of what we expect our clients will earn in terms of earned time credits. Now, I have just a very rudimentary sheet that I use, but Pablo gave me this one as a good example that tracks a number of different milestone dates. So you'll see on the left corner here, the release date with good time credits was April 12th, 2027. And then on the right side, you see the milestone dates. And the milestone dates keep track of the RDAP early release because that can be stacked with the earned time credits pre-release. You have the FSA supervised release. That's the 365 days that you can get off because of earned time credits. You have the FSA pre-release custody, and that's the pre-release custody in home confinement or an RRC. And then you have the Second Chance Act home confinement. So RDAP, Second Chance Act, and earned time credit can all stack in an ideal world, although we know that the Bureau of Prisons isn't necessarily doing that because of claimed administrative difficulties and bed space. This sheet also does a really nice job of keeping track monthly of how many earned time credits a client is expected to earn. So 10 in December 2023, 10 January 2024, 10, 10, 10, and then you see they're at the 15, which means that they have moved down into a different risk category. So again, having these things in your file as you start to negotiate and work your cases is really important. All right. So I want to talk just about some common problems, and the common problems probably won't surprise you, in large part because they're the things that Beth flagged and they're things that I've been talking about paying attention to when you negotiate your pleas and when you review the PSR. The first real problem that we're seeing concerns issues of eligibility. And the first component of that is just misclassification. So the Bureau of Prisons has that list of ineligible offenses, but it turns out that they don't do a really good job of determining whether or not someone's offense falls on that list. So I've had clients who are statutorily eligible, no question, be told by the Bureau of Prisons that they are in fact ineligible. So for example, I had a client who eventually pled guilty to conspiracy to distribute heroin. She was originally charged with distribution of heroin resulting in death. In the middle of the trial, there was a plea deal. She ended up taking the plea deal to conspiracy. The resulting in death was still in the PSR. It was objected to. There was no finding that the distribution of heroin resulted in death, but the Bureau of Prisons was like, you know what? She's ineligible because of the distribution resulting in death, even though that wasn't part of the conviction. So eventually we were able to remedy that, and the Bureau of Prisons, I now have a declaration from them that concludes that in fact you have to have been convicted of distribution resulting in death for that ineligibility marker to apply, but you really want to look at how they're classifying. Another common misclassification that we're seeing is someone will plead guilty to conspiracy and they will have a role enhancement, and the Bureau of Prisons will treat that as the equivalent of having pled guilty to the substantive offense. And the substantive offense plus a role enhancement would likely render you ineligible if it were meth or heroin, but the conspiracy conviction doesn't. So again, you really want to be careful and make sure that your clients are being told properly whether they're eligible. The other thing that I think goes back to the question of the detainer and earning versus, or eligibility versus non-eligibility status, is this idea of multiple convictions. So remember that the statute lists all of the offenses for which someone is ineligible. And the statutory language is really clear. It says a prisoner is ineligible if they're serving a sentence for a conviction under, and then it lists that statute. So the Bureau of Prisons has been saying, okay, well, because of that language, when that language is read in conjunction with 3584, it doesn't matter if someone is convicted of 3 counts of conviction, 2 of which are eligible and 1 of which is ineligible. Their position is that because they are treated as one sentence for administrative purposes, the ineligible offense will taint the eligible offenses. And so what that means is you could have somebody who has a conspiracy and a 924C conviction, and they will be ineligible even though the conspiracy conviction renders them eligible. Where you really start to see this now is with terms of supervised release. If somebody has a 924C conviction, they serve their prison sentence, they get out on supervised release, they get popped for another conspiracy conviction, they get revoked on that 924C supervised release, the BOP takes the position that they are in fact ineligible to earn time credits with respect to the entirety of the sentence, the supervised release term and the substantive criminal offense, even though the supervised release term is only 2 years by statute in most cases, right? And they're clearly not serving that 2 years for the entirety of the new conspiracy conviction. So advocates, and I have to say, there's 2 advocates in particular, John Warren and Patricia Richmond in South Carolina, who have fabulous briefing on this issue, and I put the case number up there. And they really do a plain text analysis of the statute. And they say, you know, once someone has finished serving the sentence for the crime of the conviction that renders them ineligible, they are not ineligible with respect to the other sentence if they would otherwise be eligible. And that makes a lot of sense given the purpose behind the statute. That case is still pending. It's in the briefing stage, but if you have this issue of mixed convictions or multiple convictions, I highly recommend you look at it. The other sort of big issues that we're seeing relate to transit time, and Beth talked about this earlier. There are actually several cases across the country that have taken the Bureau of Prisons to task in its interpretation of when you are in earning status. So the statute says 3632, during official detention prior to the date of the commencement of the prisoner sentence, they will not earn. But then 3585 defines the commencement of the sentence as when someone is received in custody awaiting transportation to. So it includes those times of transport. But the Bureau of Prisons in their CFRs have actually taken the opposite position, and they said that you only are in earning status when you are designated to the Bureau of Prisons facility where you're going to serve your sentence. So the conflict between the statute and the regulations there, I think, creates prime fodder for litigation. And so there is the case that Beth cited earlier out of the Western District of Washington, and there are also a couple of cases, I think, out of New Hampshire, where the courts have said, no, the person gets credit for the time spent in transit. Another issue that we've had or that we've seen is this idea of opting out or opting in. So we know that if you are successfully participating, your credits that you earn shall be applied towards time in pre-release custody or supervised release. You are not successfully participating when you have opted out. And Beth talked about how you can be determined to have opted out. So 2 issues really arise here. One, our clients often aren't aware of what it means to opt out. I'm sure all of you have heard they get hauled into their unit team's office. They're talking about various programs. They say you can be on the wait list for RDAP or this other program, but if you're on the wait list for this, then you can't do that. And so our clients say, well, yeah, just like take me off the wait list. I'm probably not going to get into it anyway because my halfway house date is approaching. And then if that's documented by staff, that's considered an opt-out. Now, where this really harms our clients is in the CFR that the Bureau of Prisons has that talks about once you have opted out, you are excluded from further benefits or privileges allowed under the FSA until you then opt in. So those credits that you earned previously, you now can't use because you're in opted out status, which seemingly conflicts with 3632 that says these credits shall be applied. So something to keep in mind is to tell your clients, do not opt out. And if you think you are being interpreted as opting out, ask your unit team if that's being documented. And then for those of us who are seeing these cases on the backside, where someone's saying, they're saying I opt out and I didn't, challenging the Bureau of Prisons interpretation of this rule or interpretation of the statute, I think is, again, really great ground for litigation. So these are just some of the common problems. There are other things. Miscalculations happen quite frequently. Somebody is not getting the right credits. You have to have evidence of what the credits should be if you're going to litigate that issue. So your clients are going to want to keep track of what productive activities and recidivism reduction programs they've engaged in. And then the other big problem that we're seeing is that people are not being allowed to cash out their earned time credits for supervised release or pre-release custody, even if under the statute, they should be eligible to cash those out. So there are a lot of issues going on with how the Bureau of Prisons is interpreting the rule and administering the rule. And so these are just four that I've seen quite a bit pop up and wanted to flag. Okay. So what do you do? Like the BOP gets this wrong. And so now you have to figure out what it is that you're going to do. The first thing that you should do is you should get the FSA time credit assessment sheet. You can do this via FOIA, and I threw up the BOP's FOIA email there. You can also ask your client to do this. And I think all of us have probably experienced how sometimes it's much easier to have our client get the paperwork than to go through the FOIA process. The piece of paper that you're looking for looks like this. It's usually a 2-sheet piece of paper, and it has sort of 3 categories or 3 sections that you want to pay attention to. Now, Beth showed you that first section earlier. It's that box up on the top left there, and that just gives you a summary of what the Bureau of Prisons has determined with respect to eligibility and earning. So you'll see at the top, they give you your assessment period, the start dates for which you've been in the program, your accrued program days, the number of days when you have not been allowed to earn, and here it's because of a transfer, and then the earned time credits towards RRC or halfway house. Up in that box, you'll see that my client here has 235, and then the FTCs towards release, he's got 365. So that's just the summary. And then when you get to the bottom part of that page on the left-hand side, you'll see sort of 4 categories. Your client may have more categories. Basically, this is breaking down the periods during which they were earning. So you'll see that that first one with a bracket of green was a start and stop date, and I know that my client earned 431 program days there. That second one in red, my client was not in qualifying status because of a transfer, and that was for 13 days. Then we get to the bottom 2 in green, and you see the start and stop dates, and you get the program days there. You have 1,024 and 251. So the Bureau of Prisons actually, if it's correct, keeps pretty detailed data about when your client is earning or not earning and why they're earning and not earning. And then on the right-hand side, you'll see on the FSA assessment, this is where you see how the pattern score impacts the number of days that you're earning per 30-day period. So if you look under risk assessment, my client was at a medium for a very long time, and then he got to a low. And you will see that he was earning 10 days under that factor column. He was earning 10 days every time he was at a medium. And then he was earning 10 days for his first 2 assessments at a low. And then after those 2 assessments at a low, they bumped him up to factor 15. So now he's earning 15 days per every 30-day time period. So you really need to understand the sheet of paper. And this is the sheet of paper that you need to get from either your client or the Freedom of Information Act. All right, so you get that. And then if you find a problem, the first thing that you should do is contact regional counsel and see if you can just resolve it. I've been doing this in a number of my cases, and I've been able to resolve things that I was shocked about. And it saved, obviously, a lot of trouble and got my clients out much sooner than they otherwise would. But if you don't get anywhere with regional counsel, or you don't think it's something you can resolve informally, then what you're going to want to do is start with the administrative remedy process. The reason why you want to do this is twofold. One, sometimes it actually makes a difference. And I've had a couple of clients where my client has submitted the BP8 and the case manager has said, oh, actually, you're right, I got this wrong. Then rendered him or said you are eligible, and my client was released within the next 2 weeks. But even if you don't convince the BOP, you're going to most likely need this for litigation in a 2241 in most jurisdictions. The Washington Lawyers Committee has a fabulous guide about how to go through the administrative remedy program, and I'm not going to talk about it in detail now because we simply don't have enough time. But suffice it to say, it is a step-by-step program that you should, in fact, read very closely so that you understand how to explain what your client needs to do. There's an informal remedy process, followed by a BP9 to the warden, followed by a BP10 to regional, and a BP11 to the general counsel. Something to flag is that while we can assist our clients in going through this process, we can't in fact submit anything on their behalf. And if we do, it will be returned to us. So you want to make sure that you're counseling your client how to do this themselves. Okay. So you don't get anywhere with that. Then your next option is really to file a 2241 in the petition where in the district where the person is currently confined. A 2241 is a claim that the Bureau of Prisons is acting contrary to law, violated the Constitution, or exceeded statutory authority. This is not the way to challenge discretionary determinations. And so by this time, it should be very clear to you that you need to understand the regulations and the statutes really well so that you can pinpoint exactly where the BOP is exceeding its statutory authority or otherwise acting contrary to law. Some of the examples of 2241s in this area include challenging the erroneous evaluation of statutory eligibility. I filed one of those and it resulted in a win for my client. Non-eligible offenses, tainting eligible offenses. That's one of the good briefing that I had mentioned from the District of South Carolina is a good model for that. The no credit accrual while in transit. Again, Beth mentioned that case earlier. That was litigated through a 2241. The refusal to transfer to supervised release. That is a potential ground for a 2241. The ability to challenge the BOP's refusal to transfer you into pre-release custody, the case law is not as good on that because it really amounts to what the courts see as a designation decision by the Bureau of Prisons, which sometimes they say doesn't fall within their jurisdiction. But I don't think because the case law is bad that we should give up there. And that's in large part because this is really where the BOP is now dropping the ball. And so putting its feet to the fire and at least educating courts about how they're not abiding by the statutory mandate to transfer people into pre-release custody could be incredibly helpful. Essentially, you can use the 2241 to challenge the BOP practices that are inconsistent with the earned time credit statute. And again, look at the statute, look at the regulations, and if you have any questions, I'd love to talk to you about this litigation. It's, I think, a pretty fascinating area of law. Now, if your 2241 doesn't work, you can get creative. We all know that the U.S. Sentencing Commission came out with a new ground for a reduction in sentence motion this year, B5. It's the other reasons category. And so if you have a client who, for example, has maybe some medical issue, but it doesn't really arise to the medical criteria in the guideline, or maybe they have some caregiving responsibilities and they don't really arise to the level in the guideline, you could potentially argue that the Bureau of Prisons' refusal to grant them the credits that they have otherwise earned is a basis to find that there's an extraordinary and compelling reason to release them. I've only seen a couple of cases litigating this, nothing I've seen under the new guideline. Previous cases have been unsuccessful, but I do think that this is an area where we can be particularly creative. The other thing to think about is what happens if my client gets home and we weren't able to resolve this, right? They had 365 days that should have been credited towards their term of supervised release, but they were released before we were able to actually get this resolved. I think that there's an argument that the court can credit those unused ETCs toward their actual term of supervised release. There's at least one district court, the Eastern District of Tennessee, that has found that if somebody had those credits and the Bureau of Prisons did not apply them, that the court was able to, under 3632, reduce their term of supervised release by 365 days. In fact, I think they did it by the number of earned time credits for both pre-release and supervised release custody. And I'm currently litigating this in the Southern District of Iowa, and I don't know necessarily that I'm going to win, but I think the argument is strong based on a plain reading of the statute. But more importantly, because you're bringing these challenges under 2241, the remedy provision of 2241 is 2243, and this really allows the court to dispose of a petition as law and justice require. And so one of the remedies can be that the court just credits those uncredited earned time credits towards your client's term of supervised release. And then finally, if you don't get anywhere with crediting the unused credits, you can always apply for early termination of supervised release. And there are numerous courts across the country that have taken into account uncredited credits in deciding to reduce a client's early or term of supervised release under 3583E. So essentially, I think that's all to say that there's a lot of areas where you can help your clients, and there's a lot of litigation that you can get involved in. And I would love to talk with anyone and hear all of the amazing things you're doing. So feel free to reach out.
So someone has asked if the ETC eligibility analysis chart be separately sent out, not just as a slide presentation. Perhaps we can also incorporate it into the how to navigate the prison system guide. There's a question regarding the administrative remedy process. What if your client is intellectually disabled or otherwise unable to submit paperwork necessary on their own to advocate for themselves? This is something we've discussed in committee meetings. Can you address that, Alison?
So I have not had that experience, so I would just be guessing at this point. So I don't feel like I can tell you what the BOP program statement says. I don't know, Beth, if you know what the BOP program says.
There's a division of BOP, and this is in the program statement that we linked to. If you can go to the next slide, maybe or maybe I can do it now. Let's see. We have, I don't know if you can go to the next slide, Allison, but program statement, BOP program statement 5410, I think is what it is. It talks about whether or not, if you want to appeal any of the earned time credits, we'll give you approval, Allison. And there's a specific division of BOP for incarcerated people with disabilities. And so it says contact this division if you have someone with disabilities. So I've never dealt with that before. And I was actually just reviewing that program statement for this presentation and saw that. So when you see it's under here under the BOP earned time credit program statement, I would just click on that and do a search for disabilities or disability and find that. It's towards the end of the program statement, but they seem to have a provision for those to help those individuals.
As Jack Johnson has always said, the BOP website has a ton of information, and you just have to navigate it in order to, he just said Special Offenders Branch. He's obviously on the call, but not participating. But anyway, the BOP website is often very helpful. And anyway, so there's another question regarding from Probation Information Network. Is anyone challenging the broad ineligibility?
You mean the fact that so many people are ineligible? It's by statute. So it would have to be, Congress would have to amend it. And I don't think that's happening right now. So no, the answer is not right now. No one is challenging the number of ineligible convictions.
Mm-hmm. Well, this is a particularly helpful resource right here. And I know, thank you to Shuli and for sending all the links. I think she responded to someone's question on an updated list of regional counsel, but this particular slide right here is particularly helpful. So thank you for that, Beth.
Yeah, we'll make the PowerPoint available so you'll have the hyperlinks.
Okay. And it also sounds like throughout this litigation, it's very useful, obviously, to read the CFRs and the regulations on all of these issues. But I know they've put both your contact information in the chat so they could reach out to you, I'm sure, as a resource. So we appreciate excellent presentation. It's a lot of information. And the only other thing I will say is that we have another presentation. If there are no further questions, we have another presentation coming up. Whoops, no, well, no, I guess we don't have any further questions. There's another presentation coming up in 2 days, which is session 3 on behavioral health in the justice system. Jacqueline Hall, who is the Chief Operating Officer of Wired for Addiction, and Tatiana Duchek, who is an attorney and licensed clinical professor, will talk about behavioral health in the justice system, a very important topic. So join us on December 20th at 2. And in 2024, we are going to start tackling the medical healthcare system and the Bureau of Prisons. So we appreciate everyone's participation, and thank you, Alison and Elizabeth. This was excellent. And so Alison just put a comment in the chat, and this was excellent. And thank you for all, and we look forward to the next presentation and seeing you in the new year. Do you have anything else, Monica, that you want?
Yeah, I'm just gonna thank you so much, Pat, Allison, Elizabeth, and certainly Shuli, who's been dropping the links in the chat. We will be sending out this recording along with the recordings from the other sessions and the links. So for those of you that were messaging me, you will get all of this information, all the links in the chat and the slides and the recording, because I know this is a lot of information. So I just want to thank you all for attending. And like Pat mentioned, there's another the final part of this series this Wednesday, and I will see you all then. So thank you very much.